Hi, my name is Wally Mlyniec. I'm the director of the Juvenile Justice Clinic. I'd like to welcome you to our program today, which we think is going to be both exciting and informative and help increase the level of practice that we have in the court today. The program is entitled 40 Years After In Re Gault, the role of juvenile defense counsel and obstacles to zealous and effective advocacy in juvenile cases. I would like to begin by welcoming our special guests today, Gerald and Connie Gault, who've come from California. We'll be hearing from Gerald later to share his insights about what happened back then at the time and how it all looks now, many, many years later. I'd also like to just acknowledge our co-sponsors for this afternoon's program, the Georgetown Law Center's Youth Advocacy Group, the American ACLR Law Review, the Georgetown University's Alumni Group, the DC Lawyers for Youth, the National Juvenile Defender Center, the Mid-Atlantic Juvenile Defender Center, and the Georgetown Juvenile Justice Clinic. The clinic, let me just say a word about the clinic. The clinic was founded in 1973. It was just a mere 6 years after the Gault decision was rendered. We were one of either the first or one of the two first juvenile clinics in American legal education. And since then, we have tried to fulfill the mandates of the Gault decision to expand the legal rights of children and ensure that children are protected from maltreatment from their parents or from the courts and the government. The case of In Re Gault, as some of you remember, guaranteed children the right to counsel and to procedural due process. In that opinion, the court told lawyers to adopt an adversarial model for legal representation, guided by the child's wishes and not the lawyer's opinion of the child's best interest. The Supreme Court also told juvenile justices, juvenile court judges, that due process and evidentiary rules and procedural regularity should not be sacrificed on the altar of best interest. Our program today is going to discuss the importance of the Gault case and discuss how the DC attorney practice standards further the premises and the promises of the Gault case. And we'll also learn about the nationwide perspective on the implementation of Gault's right to counsel. I'm going to make three introductions now, and the program will proceed. I will refer you to your materials, which have extended biographies of all of the speakers. Following me will be Judge Anita Josey-Herring. She was appointed to the Superior Court bench in 1997 and is currently the presiding judge of the family court. In her capacity as presiding judge, she led the development for the attorney practice standards that we'll be discussing today. Following the judge will be Patricia Puritz. Patti has worked for years. From 1985 to 2004, she was the director of the American Bar Association's Juvenile Justice Center, where, among other projects, she led the creation of the National Juvenile Defender Center. Patti is now the executive director of that organization, and she'll be speaking to us about the national implementation of the Gault decision. Professor Henning, who was formerly from the Public Defender Service and is now the deputy director of the Juvenile Justice Clinic, will be speaking next. Chris will further introduce the panelists and will lead the discussion on the role of defense counsel and obstacles to zealous representation. I hope you all enjoy the program today. The program, we will attempt to get CLE credit for those of you from Virginia, and of course for DC, for the family court, we'll get credit. So with that, I hope you enjoy the rest of the afternoon. There will be a reception afterwards. We invite you all to stay for that. And now, Judge Herring. Thank you.
Thank you so much for inviting me. I really appreciate the opportunity to be here. I'm a Georgetown alum. And as I was saying to Chris Henning and Wally Mlyniec, when I was a student here, we only had the building across the street, which was a faceted building in that you had the library there, you had the classrooms there, you had everything. You didn't have dorms right here, and you certainly didn't have a sports facility or anything like that. And that beautiful library did not exist. I guess we were probably getting charged for it. No. Wally says no, we were not. Wally says we were not.
All donations.
All donations. Well, there you go. That's good to know. Georgetown has great facilities, and it's a great school. So it's a pleasure for me to be here today. I do want to say that while I was the chair of the Juvenile Subcommittee at the time these practice standards were developed, obviously there were lots of people on that committee, and lots of people contributed to these standards, including Chris Henning, who we always had working on everything, and Georgetown, I'm sure, understands how much we've borrowed Chris's sort of knowledge to deliver certain projects or several projects in our court system, as well as all of the representatives from the different agencies involved in juvenile justice. Everybody had input in the process, and it was really a fun committee to chair. I think we had fun over several years working on different issues related to juvenile justice in the district. Juvenile justice is an area that is a very important and hot topic or subject area today. There's a lot of energy in the city to really focus squarely on how to improve the process so that children have good representation if they're involved in our juvenile delinquency system or neglect and abuse system, but also there's a lot of focus on getting good outcomes for youth in our city. When I was a public defender back in 1988, I believe, there was not a lot of focus on improving this area of juvenile justice, and so I think we're all very happy to see so many energized people wanting to make sure that youth have good outcomes and services and good representation as they're proceeding through our system, to the extent that they are involved in our delinquency system, and to the extent that there are opportunities for diverting juveniles. I think we're all in favor of that, so that they don't continue to progress through our system. I was just meeting earlier today with Vinnie Schiraldi, the director of the Department of Youth Rehabilitation System and Services, and we're always looking at how to improve aspects of the system. For example, we're very concerned, and have been for really the last several years, about those kids who are falling through the cracks, who have mostly family issues and minor delinquency issues, but sometimes those kids often stay longer than kids that have pretty entangled juvenile histories in our delinquency system. And so today we were talking about what the city is willing to do to really address the needs of those kids who really end up staying in our system much longer than we believe they should, given their dominant family issues. And so I'm hopeful that the city will stay focused on this issue, hopefully for years to come, so that kids can start out who deserve a short stay in the system, having a very short stay with the right focus on their family or in their individual lives that they need without getting deep into the system. It's important to have these practice standards, and I believe it was the consensus of the group to establish these practice standards at the time I chaired the Juvenile Subcommittee, because we recognize it is critically important to have really good representation in court. Not just adequate representation, although the standards set a bar that is one that is consistent with our ethical obligations as lawyers, and particularly as defense counsel in juvenile delinquency cases. But we really hope that people do more than meet minimal standards. We want them to be prepared to understand that when they're representing young people, it's a very serious endeavor. In the District of Columbia, while juvenile matters are confidential, if a person enters our adult system, we have voluntary sentencing guidelines, and their juvenile contacts or involvements are factored into decisions that are made in terms of how much time, if any time, they're going to get in jail when they enter our adult system. And so it's really important for us to be focused on good representation and not just see juvenile court as kiddie court, and not just as a court where people are getting experience, but we're really encouraging everybody by these standards to really be well prepared, to do discovery, to file motions, to involve the client in the decision-making process, understand that it is the client's case, to explain things to the child at an appropriate level given their age and any limitations or strengths they may have. The practice standards require lawyers to participate in annual meeting training standards and requirements. And the reason that's important is that we want everybody to be current, to stay abreast of new changes in the law, new legal developments, but also psychosocial advances. We want to make sure that there's a mix of not only legal preparation to represent kids in court, but also we want lawyers to understand the brain of a child, their development, what issues are facing kids currently. And so the standards really set out a requirement for lawyers to have a certain number of credit hours annually involving legal training and preparation, as well as a certain number of credit hours involving the psychosocial educational components of dealing with young people. And so that's a nice mix, we think, that will really make sure lawyers understand how to deal with young people, how to interact with them, and again, are well prepared in terms of every aspect of their case. The standards also require lawyers to stay involved with their clients after a disposition if the case happens to go that far. And the reason for that is that a lot of kids who get committed are, or in the past had been just sort of left to deal with the Department of Rehabilitation, Youth Rehabilitation Services, with maybe some assistance from a PDS lawyer who's assigned to the Oak Hill facility. But we want lawyers to think in terms of communicating with the court about needs that their clients have after they're committed, even though the court has very limited jurisdiction. We think this kind of zealous representation is what was envisioned by the board of, by the ethical requirements that we're all bound to here in the District of Columbia. And we want people to understand that family law practice and practice in the delinquency court is just as important, if not more important on some levels, than practice in the adult system. Because what we do at this level as lawyers and judges has a long-term impact on the youth and on their families in terms of whether they even enter the adult system, or if they enter the adult system, whether they their record is such that it was influenced by the fact that they had really good counsel at the family court level, or if they didn't have adequate counsel. Unfortunately, we think the standards should address through our panel's process an oversight process, lawyers who are not quite making the standard and meeting the mark. And I say that understanding that everybody works really hard to do a good job. We all have more than enough work to do. But I think we are all involved in CLA. Judges take a lot of training or participate in a lot of training all year long. I participate in a lot of training. And I also train other people. And we're just asking the bar to do really the same. To stay current so that they can be very effective in court. We know that lawyers and judges don't always agree. That's not the point on what happens in the context of the courtroom. But I think it is important, and I think judges feel good about lawyers who come to court, even if they're challenging the judge, if the lawyer is prepared, if the lawyer is relying on cases, or if the lawyer is relying on a legal principle or making a reasonable argument where it is clear that the lawyer prepared before they came to court, and they're not just standing there emoting and asking you to do something for a client because they feel that way, but that the lawyer is actually prepared as a lawyer and not just standing there saying, well, Judge, please don't do this because I think that's just not a good thing. We want to feel like we're engaged in the practice of law or in the legal profession in our roles as judges. Obviously, we're not advocating, but we want to feel like when lawyers leave our courtrooms that they are real lawyers and not just somebody who walked into the courtroom who decided to emote and ask the judge to do a particular thing, who really has not spent the time to represent the clients in the way that they're obligated to do it based on the rules of professional ethics. And so I just wanted to stop by to say I hope you have a great training. I actually have a meeting back at the court. I'm on an administrative law judge commission, and we're voting on a particular issue tonight, and I always like my vote to count. And so I am going to go back to make sure that I am present and that I can vote to influence that process, hopefully, in a just way as well. So enjoy your training. It's all exciting, and thank you so much.
Good afternoon, everyone. Patti Puritz with the National Juvenile Defender Center, and it is just great to see this room here full of people today ready to talk about and focus on the issues of juvenile indigent defense and counsel for children and the related due process issues. It's one of my favorite things to talk about, and it just warms my heart that this room is full and ready to go, and thanks to all our sponsors for putting this together. One of the things that I did in preparation for not only this, but for a lot of events like this happening around the country this year, celebrating this 40th anniversary, was to read and reread the Gault decision, to read the related pleadings that were filed and the amicus briefs that were filed, to listen to the oral argument. And for any of you that are interested in this topic, I would urge you to go and do that if you haven't already. It is really fascinating to understand how all this came about, what the tensions were, and how some of those issues have yet to be fully resolved in terms of children's access to counsel and the role that that counsel should play. As Wally said in his opening, it is emphatically clear when you read the decision that the Supreme Court says that juvenile court is an adversarial place. Whether we like it or not, it is in fact an adversarial place. That doesn't mean we don't care about the children that are there, about their best interests, about all the things we can do to help and treat them. But first and foremost, it is an adversarial place, and children need to be protected in that environment. The court clearly said kids are entitled to due process, and that defenders are the guardians of that due process for kids. And I know that it is not true in D.C., having been here for a long, long time. The bench and the bar in this city are phenomenal, and you lead the way across the country in so much of the work that you do. But I've been asked to speak for a few minutes to you about the national scene. And I think it's important for you to know what's going on across the country so that you can continue to lend your expertise and help other systems as you work to also improve your own. I would say that one of the most important things we see in our work around the country is that the right to counsel is really viewed as, in many ways, a gratuitous privilege, something that some get and others don't get. But that there's not a strong feeling out there in many jurisdictions and communities that we are in that this is a constitutional right that children are entitled to, that it's not optional, that some get and some don't. And I think that it is very troubling when you see in many places that this is just not taken seriously. There is sort of a malaise that has set in in many juvenile courts around the country, and these systems, these indigent defense systems, have not been checked over the years. They went in place about 40 years ago, and in many places they've not been revisited. There are some assessments that the ABA and our organization and a few other places around the country have conducted, but for the most part, systems were put in place and they have not evolved. They have not changed. They have not incorporated principles of adolescent development and other things that we know greatly matter and that the judge just referred to, that you see reflected in a lot of your practice standards that will raise the bar and raise the level of practice. So let me just talk about some of the things that we see in our travels around the country, some of the systemic issues and institutional barriers that impede a child's access to counsel. And please understand that this is not to say that there aren't wonderful people out there trying very hard to do good work. It's often the situation and the system that is just absolutely broken and makes that work very, very difficult. One of the first things is the timing and appointment of counsel. When actually does a child receive access to their lawyer? Is it after the detention hearing, or is it before the initial hearing? Is there a chance that that lawyer has to have a meaningful interview with that child, or are they just sort of plucked from the courtroom and called to stand next to this child and representing that child when they don't even know their name and haven't had a chance to review the files? And that is a lot of what we see going on around the country, that lawyers are appointed sometimes late in the case, that there is not an opportunity for a meaningful initial interview, and that it's just, from that point, it's just building on bad. A lot of you that are immersed in this work every day know that detention is often the gateway to staying in the system, and that it is really important to put your best foot forward up front at that initial detention hearing. Another thing we see across the country is the extraordinary numbers of children that waive their right to counsel without prior consultation with counsel. Certainly children have the right to waive counsel, but when you sit in court after court, in state after state, you just begin to see that there is a subtle way in which many children are coerced into waiving counsel before they've ever had a chance to learn more about what that might mean. And if they do receive a juvenile adjudication, what are the collateral consequences of that adjudication? It gets worse and worse every day, and the long-term consequences of a juvenile court adjudication are very serious and very long-lasting. Most cases in juvenile court, and again, I'm not saying this is true in your community, but most cases in juvenile court result in plea bargains. And all of this happens very quickly. These plea agreements are structured, at the same moment counsel's being waived, and in a lot of times when we visit courts and we sit there, maybe 2 minutes, maybe the entire case is resolved, from being introduced to the attorney to some quick little something to entering a plea. And then when we follow up and talk to children in the halls and families outside, it is really very clear that they often, not always, but often don't know what they have just done and what the consequences of that action might be, whether it's 3 strikes you're out, or whether they've just been swabbed for DNA during that process, which is going off to a state data bank and a federal data bank, whether it's going to affect their employability later down the road. Driving. I took my daughter for her permit the other day, and one of the questions right there on the form that you have to fill out in Virginia is, have you ever been to juvenile court? If the answer is yes, you go here, not over there. The consequences start to kick in very, very early, and the large number of plea bargains without any true vetting of these cases feels more like a case management tool than anything else. It is a way to get these cases through the court very quickly. Defenders around the country, and this is true of the indigent defense system generally, I'm well aware, are struggling with overwhelmingly high caseloads. Again, I'm not sure that's something you grapple with here in D.C., but we see defenders in most places around this country with hundreds and hundreds and hundreds of open juvenile cases at a time. And in a lot of the rural areas, a lot of the defenders work part-time and still have these caseloads, maybe not in the hundreds, but their ability to travel 200 miles when they do regional work in rural communities to meet and talk with their clients. It is a very cumbersome process, and I don't think our community as a whole has been able to really work sufficiently to address these caseload issues, which connects to the resource issue. We see defenders around the country, unlike you here, that, honest to God, don't have offices, don't have telephones, don't have files, keep boxes under the desk in the courtroom, don't have access to Westlaw, don't have the trappings and the ability to really perform the defense function. And I am not exaggerating, and I am not making this up. We're very lucky to practice in a different kind of setting, but when you get out there around the country, you would just be amazed at the lack of resources that juvenile defenders have to do their job. And I'm not even talking about access to experts or social workers or investigators. For most, that is beyond their imagination that they could even access such things. There is virtually a lack of training and supervision around the country. Not true everywhere. There are some outstanding offices where training programs are in place and there is some oversight and monitoring and supervision and mentoring, but that is not the case in most places. Defenders, as well as judges, frankly, do not keep up with the law. They are not aware of things like the Roper decision that gives such wonderful language to help defend a child and make arguments around categorically less culpable. It is a big problem, the lack of supervision and just any sense of checks and balances in the system overall. There is a culture that has set in many places that really focuses still on this notion of best interests of the child and that we're all here to help the child. So what is the point of due process in the face of helping the child? And frequently what we see is a lot of pressure on defenders to just go along, to not stand up and challenge the court, to not file motions, to not conduct interviews, even when it's possible, because we know this family, we know the siblings in this family, we've seen them before, we need to intervene, we want to help, and often very well-intentioned people are willing to cut all sorts of corners so that those children can be pulled into the system in the name of receiving treatment and services. And you know in your own experience that even in the best of circumstances, more often than not, those treatment and services do not follow. There are big issues around the country with pay parity, whether it's juvenile defenders and juvenile prosecutors both entering the system at completely different levels with the same level of experience, or even, honestly, within the indigent defense structure, where juvenile court is tagged as kiddie court. And it's a place where lesser lawyers are, and that it's not until you work your way up and out into trial court that you become, into adult court, you become a real lawyer. And a lot of times it is within our own indigent defense system itself where juvenile court is kept down. And I can think of state after state that I've been to where defenders with an extraordinary amount of experience start in juvenile court, move up to adult court, want to return to juvenile court. That's where they would like to base their practice, and they are allowed to go, but they have to take a pay cut and go back to where they were when they first entered juvenile court. So there's a huge disincentive at work. And those issues of parity are also glaring within communities where defenders work part-time and have outside practices in order to, sustain their practice. We know of a number of communities where judges have agreed to hold court more often, but the defenders say, no, we come here once a week and that's it, and we're not coming any more than that. So if that child has to wait in detention for a week, well, sorry, that's how it is. We need to address issues like this and help elevate the practice of juvenile defense all over the country. And part of how we need to do that is by addressing what has also been a gap in leadership on these issues. I think this has really been changing over the last few years, but in many states there's just not yet, there will be, but there's not yet an organized network of juvenile defenders that have penetrated the leadership structure, that have the time or ability to even do that. So there is just a floundering and nobody to go to bat for you. No one who has your back if you try to step out and do something more innovative in juvenile court, if you're before a judge that refuses to hear motions, for example. I know that's an unimaginable thing to think about here in D.C., but there are lots of places where defenders are just simply not allowed to file motions. They can make some oral arguments in court and that's it. And these issues are impacted and affect all the branches of government. Juvenile defenders alone cannot solve these problems. We have to work across government. We have to work internal to the indigent defense system. We have to work with bar associations and state supreme courts across the country. And I believe that if those things happen, that things will change as they have begun to. And I wanted to give you a sense of what we see going on across the country, but that really was not the message I wanted to leave you with. What I really want to say is that things are changing, and that when you bring focus and attention to these issues like you're doing here today, and you try to figure out ways to address these problems piece by piece, it is amazing some of the changes we've seen in the last few years. It's really a very good time to be involved in these issues. And I can just give you a few examples of things that have happened in the last year or two, or in the last few weeks. In Illinois, for example, the state legislature has just passed a bill, and the governor signed it, and there's an appropriation in his budget to create a statewide juvenile defender resource center. That is something that is desperately needed. If every state could have a resource center where juvenile defenders could call and get the backup and support they need, could work on a legislative agenda, there's training, there's so many things that a resource center could do, and that is going to become a reality in Illinois in the next couple of months. A wonderful innovation that I just love in Pennsylvania is the Juvenile Defender Association of Pennsylvania. And some Pennsylvania colleagues are here in the room today, and I'm sure would be happy to share with you about this association. I know this sounds like such a small thing, but juvenile defenders across the country are disenfranchised. There's not been an organized network. And to create a statewide association that is run and managed by juvenile defenders, setting their own agenda, determining what their training needs are, and their legislative needs, is going to go a long way to moving those issues forward in the state of Pennsylvania. It's a great accomplishment in Louisiana. Post-Katrina, the juvenile defenders in New Orleans were able to create juvenile regional services. It is the first standalone office of its type in the country that has negotiated with the Office of the Public Defender to outsource all the juvenile cases to them. It is a fantastic, comprehensive office, fully staffed with investigators, social workers, support team, and they are just providing first-rate legal representation to kids in New Orleans at this moment. There are new clinical programs cropping up all around the country that are doing very innovative practice and policy work, and that is new. From time to time, new clinical programs emerge, but there have been very few that really have focused on juvenile defense and juvenile-related policy to juvenile defense, so that is exciting. There are new standards and guidelines, not the least of which are your own, that are a way to convene people together and help to elevate the practice. There are networks and support systems that are growing, and I think a testament to this work has been the recent creation by the MacArthur Foundation of something called the Juvenile Indigent Defense Action Network, where they have dedicated, for starters, over $1 million to bring 8 states and potentially the District of Columbia together to work strategically on some targeted issues, to pick an issue of concern, to resource it, to work on it across states, and then to move on to the next issue. It's one of the first funding streams that has opened up in this area for a long time, and to have a big foundation step forward and say these issues really matter. Juvenile justice reform as a whole is not going to take hold in individual states and jurisdictions across the country if juvenile defenders aren't at the table. And we've got to figure out ways to help them. I would urge you to learn more about the Mid-Atlantic Juvenile Defender Center, which is a regional center operating in this area that stands ready to help you with whatever your practice and training needs might be. And where is Melissa? Melissa Goman is the director of that center, and Chris Henning is the co-director, and I hope that you will rely on that center to help you move some of this work forward. So that's just in a nutshell, a quick overview of some of the national issues and problems, but hopefully some information about some innovations that are occurring and things I hope you will join in on. Thanks again to the organizers of this symposium, and most especially thank you to Jerry Gault, who just inspires me so much every day and is always there for us anytime we ask Jerry. It just means the world to us to have you with us today. Thank you so much.
So we're going to ask our panelists to come up and join us at the table. The heart of the program today is to talk about the role of counsel here in the District of Columbia. And we heard from Patti, what the state of the nation is with regard to juvenile defense counsel, and the problems in throughout the nation are quite intense. And so we don't have nearly the level of problems and complications with the defense bar as you will see out in the nation. So what we could do for the next hour is pat ourselves on the back and say, every kid in Washington, D.C. has a lawyer. Every kid in D.C., gets to meet with their lawyer before the first detention hearing. We have attorney practice standards. And we don't have kids waiving the right to counsel. So that could be our program. But that's not what we're here for. We're actually here to push ourselves to the next level. And we have 4 goals that we hope to accomplish over the course of the next hour. One thing is we as a community, meaning the D.C. Superior Court, the D.C. Juvenile Defense Bar, the clinics, all of us need to reinvigorate our commitment to the attorney practice standards. So that's one thing that we wanted to accomplish. As Judge Josey-Herring said, there was a committee that developed the attorney practice standards back in June of 2004. We had a major training, mandatory training back in the summer of 2004, and that's the last training we've had on attorney practice standards. So we wanted to have another one where we revisit this and sort of reinvigorate our commitment to the standards. The second thing is this gives us, as members of the defense bar, an opportunity to ask ourselves, Are we living up to the attorney practice standards? Are there things that we're doing well? Are there things that we could be doing better? So that's the second goal. The third goal is really a first opportunity that I know of for us to have a conversation here in D.C. about what our systemic challenges are. They may not be as broad as they are across the nation, but there are some. So what are the systemic challenges to we as defense attorneys living up to these attorney practice standards? And so we want to have a conversation between the bench and the bar about that. The fourth goal is just to start a dialogue about how we might address some of the obstacles or the systemic challenges that we see, whether that be training, whether that be new policies and procedures, whether there are ways in which we, as members of the defense bar, might correct any misunderstandings about what our role are, if there are any. So what we have is to facilitate that conversation is a panel, very esteemed panel. And I know a couple of folks on this panel actually changed plans to be here, so we really want to especially appreciate those who were able to join us. So we have, I really want you to refer to the speaker bios because I really want to get into this discussion. But at the end of the table, we have Judge Patricia Broderick from D.C. Superior Court, particularly the family court. She sits on a juvenile calendar right now. We have Judge Zoe Bush, also from D.C. Superior Court, sitting on a juvenile calendar now. We have Hannah McElhinny, who's the chief of juvenile section at the Public Defender Service. Geoffrey Harris from the D.C. Law Students in Court. And we have Wanda Williams, who represents the juvenile CJA panel. So what we're going to do is just have a conversation, and I cannot stress this enough. This is not a staged or scripted conversation. The panelists know what the general areas of questions or the general topics that we're going to cover, but they haven't heard each other's answers. So I also want to be clear, I don't expect there to be 100% agreement on what the contours are of the juvenile, the role of juvenile defense attorney is in the District of Columbia. I also don't expect there to be 100% agreement on what the systemic challenges are or the obstacles are to zealous advocacy on behalf of kids in D.C. But this is an opportunity to start that conversation and see where we go. So I'm going to keep the focus on these guys and maybe just go to the other microphone so it works. We'll try to ask them questions.
You want a stool? You want a stool?
I really just want to get us started. Actually, I talked about enough, and I think this is so I want to start us off by really just revisiting the role of defense counsel. What are the basic function of defense counsel, and getting a sense for whether there is agreement or consensus about what our role is here in D.C. So I want to start by asking the defense attorneys to sort of just to get us started, what is the role of defense counsel based on the rules of professional conduct, based on the attorney practice standards that we have? Hannah, do you want to?
Sure. I guess I would divide the obligations of defense counsel into two different areas based on these materials. One is our obligation to give kids the ability to make informed choices, and the other is our executing those choices on behalf of kids. So, you know, that each one of those then obviously has a bunch of components. So the ability to giving kids informed choices means educating them about my role and their role and the roles of the other players in the system so that they know what to expect going forward in the case. Educating them about the nature and the potential consequences of their charges so that they know why they're there in the system. And then investigating the case thoroughly from before I even meet the kid all the way through disposition and post-disposition so that I can tell the child the likely outcomes of different choices that he might make in terms of what his own choices could be. And then the second part is, sort of obviously, whatever he or she chooses to do in terms of whether to go to trial or not, what kind of defense to present, whether to testify or not, then my job is to execute those choices.
And you talk about executing choices that the client has made, and these are kids.
Right.
kid comes to you and says, I want to do something that you know is completely crazy, probably not in his or her best interest, what do you do?
That's never happened to me. No, I'm just kidding. Well, that happens all the time. I mean, I think that happens, my guess is probably more often with juvenile clients than with adults, because kids are, required to be impulsive decision makers. But by definition, right. So my job is with kids always to give them as much information as I can, and to be making sure that what their choices are reflect what their goals are. So if I know, for example, that a child wants to get out of secure detention as fast as he possibly can, I understand that that's what he really wants. If what he's saying to me is, I just met you today, I want to plead guilty, I want to plead guilty to all the charges right now, I have to find a way to make sure that that child understands how that choice relates to his goal. And often, pleading guilty to all the charges on the first day does not result in an earlier release from secure detention. So, the way that happens is through trust building, where one of the things I do is make commitments and follow through on them. And then also repeating over and over again in simple terms what my role is vis-a-vis the kid. I'm going to do what it is you ask me to do. But let me make sure I understand what it is you're asking. And let me make sure you understand how what you're asking for will play out in terms of what you want. So I say over and over again, when I meet a kid, I say most kids want to get released from jail. But I can't do anything until you tell me what you want. Is what you want to get released from jail? And 99% of kids say yes, and every now and then a child says, no, I don't, because of some other circumstance that's going on, and so that's how that begins.
Thanks. So, Geoff and Wanda, if you don't mind, can you add to that? How would you define your role as defense counsel? What do you see as your basic functions?
I'm in agreement with Hannah.
I think much like what Hannah said, what we work with our students on is making sure that they explain to the client right off the bat, my job is to secure for you as much as I can what it is you want. And our students explain to the client, I'm not your social worker, I'm not your probation officer, I'm sure not your mom or dad. I'm here to work for you and try to get what you want, so let's talk about it. Now, you do have the problem, of course, all the time, not all the time, but often, of your clients having unrealistic expectations. And I think at that point it becomes part of the student's job, or the student attorney's job, to counsel the client and explain, these are realistically your options. Now let's talk about these possibilities and what is it that you'd like us to do here. I think our students enjoy the opportunity to do that kind of counseling. We work both with adult clients and juvenile clients, and our student attorneys are typically younger than their adult clients, and so there's not so much counseling going on there, because the adult client is looking at them like, I know so much more about this system than you ever will, and certainly you do now, so don't tell me how to do this, let me tell you what we're going to do. They don't get so much of that with the kids, so it's an aspect of the practice that they enjoy.
Right. So the heavy function on counseling, giving advice when working with kids.
Right.
Okay. So let me ask the judges, are you in agreement with this? Is this a fair assessment of what the role of defense counsel is? Is it to, in fact, defer to and follow the direction of clients?
It sounds about right, and I tell you, I know
about right.
I know you said we're not here to make nice and pat each other on the back, but let me just say, I see so many familiar faces in this audience that I've been seeing for, I don't say, more than a decade, years and years and years. And it's just gratifying to me that we have committed counsel in the District of Columbia who understand family court, who understand family court issues, who understand the difference between the different divisions of the family court and how they interact, and how you graduate from one system into the other, because I know the lawyers here know that you can graduate from the neglect system into the juvenile system into the adult system because they've been through it with their clients before. And there's nothing more valuable, I think, to our young people who represent the most vulnerable components of our community and who also have the most potential for redirection and change than to have committed counsel who care about kids, who want to work with kids, who understand their issues, who understand their communities, and who understand the resources that are and are not available for them. And that is so much more than I know a lot of other people have in other jurisdictions. So I'm just glad to see you all here, and yeah, that sounds about right.
That's good, then, actually. Just Broderick, did you want to add to that?
Yeah, I agree with everything that they've said, but I, in a sense, disagree a little bit with the line that they're not social workers. Because I do think that these are kids, and they're not adults, and they don't always hear what you have to say the first couple of times. And so you do need to spend a little extra time with them. You do need to, in a sense, counsel them. They do look at you as role models. So I think there are extra aspects besides advocacy in representing kids.
So, I mean, if you would, I mean, what if you had to come up with a list of what do you expect, the minimum expectations from the lawyers who appear in front of you? What is it that you're looking for?
Oh, I expect tons and tons, and everybody in here has been before you.
It can be a long list. It's okay.
We're all active. I expect counsel to be professional but patient, and to have spent time with that young person before they come into the courtroom, to have found out as much about that young person and their families and their needs, because that the law is just a given. I mean, who doesn't? I mean, truly. Well, it's very seldom that I find a lawyer who just has no clue. And if that's the case, then that gets fixed too. Don't. I know we're going to get to this later. What's the difference between the guardian ad litem? Right. And but don't be afraid to find out what it is that's driving that child's behavior. Because I can tell you that's what I'm trying to figure out. What is driving that child's behavior? I don't think this is just a little midget criminal. This is a young person who has many, many challenges and obstacles and many, many needs. And that doesn't mean that they don't have any right to due process. That doesn't mean you shouldn't come in and file a motion. It doesn't mean you don't have discovery. But you are so much more than just that. And I expect so much more from you than just that. And I don't think you're betraying your client's interest if you indicate to the court, my client has this need, and it needs to start being addressed now, in JM 15, the first time you come to my court. And I think your client is much less likely to repenetrate the system and keep coming back before me, or to go upstairs to the second floor where they're just screwed. And so it's not violating your ethical duties to be a zealous advocate just because you really understand that kid's needs and find a way to call attention to it with the court. It doesn't mean they're involved just because they're in the wrong educational setting. It doesn't mean they're involved because their parents are drug addicts. It doesn't mean that they're involved because they have an untreated mental illness. But all of those problems are going to need to be addressed, whether that kid was involved or not.
And knowing how long it takes us to get the resources in place. And that's so frustrating to me because kids' lifetimes pass and they're still waiting on that referral. That's my most hated word. I've made the referral. Well, that means in about a year, we'll see something. So we should start that year sooner. And again, it doesn't mean the kid's involved. I've even suggested something that we really aren't supposed to do, which is that we even start some of the psychologicals. I won't look at him. I won't read him. He doesn't have to talk about the offense. But if he needs it, why don't you just let us do it and get it started, get the counseling in there? If he's found not involved, he's lost nothing, and he might have still gotten some help.
Okay. So if I may, just a little bit.
Yeah.
This, I think, goes to one of the central tensions all the time in the delinquency system, right, is that we're poised sort of in between the criminal system and the neglect system in some ways. Mm-hmm. That kids are there for rehabilitation and services, not for punishment. But on the other hand, they're charged with criminal offenses, and one of the consequences is loss of liberty or being separated from your parents. So, and due process applies. So I agree with what both judges are saying to the extent that the attorney has the responsibility and the obligation to understand your client and where your client's coming from and what their needs are. I disagree with the fact that we wouldn't be breaching an ethical obligation to disclose it to the court unless that's what the client wants. So there are lots and lots of kids I know who it's not just about being found guilty or innocent. It's also about whether or not they want the services that the court is providing. So one example is drug use, drug testing. Kids all the time come in and they routinely get tested for marijuana and cocaine and PCP, and those results are available to the court. I know that the judge is going to look at them. I know that there's no hiding the use of these things. And it's part of my initial interview with a kid. Do you use these things? Have you used them in the last 30 days? And I ask the child whether or not they want help with what their substance abuse issue is. And I also let them know whether you want help or not, we're going to be talking about this in the courtroom. Because it's not going to come from me, it's going to be coming from the drug testing results from the drug testing unit. So here's what I can do, and here's how we can talk about it, and here's what the choices are going to be. But you don't have a choice about disclosing this need on your part. Sexual abuse history, alcohol abuse, having witnessed violence or been a victim of violence, those are different because those are things that the judge may or may not know about. And the child may have a real need based on those experiences. But if the child is saying to me, I am telling you this because you're my attorney, and I don't want anybody in there to talk about it or to know about it, I can't disclose those things in court. So even though it may not be related to the charge that the kid is there for, if I were the child's parent, I'd absolutely want to know about it. If I were the judge in charge of rehabilitating the child, I'd absolutely want to know about it. But as the child's attorney who learns about that through the course of my zealous representation of the child, I can't disclose it unless the child authorizes me to do that or wants me to do it. So it's complicated, I think, in that way.
It can be complicated, but I don't think the presumption should be that the kid doesn't want you to divulge it. And I don't participate in that part of it, but I think if a kid is embarrassed to ask questions in class because they don't understand, if a kid can't read, if a child's in the wrong educational setting, and so they become disengaged from school, and that's what is mostly driving that behavior, at some point I'm going to see the all-S. At some point I'm going to see the lack of attendance, and I'm going to figure it out. And it just seems unlikely to me that that child would say to you, hey, I don't want that cycle. I don't want an updated IEP.
Right.
I don't want it. Because I think they want to be in an educational setting where they're not embarrassed to ask a question. And maybe 1 out of 5 kids will say, oh, no, don't update my IEP.
Right.
But I mean, what do they care?
Well, so this is what I mean about informed decision making. I wouldn't presume that a child didn't want a judge to know about it, and I wouldn't not ask a kid what they wanted. But I will say, here are the consequences of disclosure, and here are the consequences of non-disclosure. So, and there's pros and cons of both things. Getting help earlier can be better because it can make the case move more quickly. Disclosing earlier can also mean that you end up either getting locked up or getting a bunch of services that you're not ready for. So I'll say, here's your choice. You tell me what you want to do. And sometimes I think it's in the best interest of the child to make one choice in particular. And the child doesn't want it, and they're resistant to it. And I take my educational role and my counseling role very seriously in terms of saying, I really want you to get on board with this. All the time repeating, I'm only going to do what you want, I'm only going to do what you want, but here's what I think. I think this is a good idea for you. But if the child doesn't authorize that course of action, then that's not a course of action that I can take. So it is amazing sometimes how kids don't want their inability to read at 16 to be something that's ever discussed in the family court. And I can say to them a million times, this is going to come up one way or another. We might as well proactively go in and ask for help because you get the help and it looks great. I mean, it's a smart, mature thing to do. Some kids won't do it. And if they won't, then that's the end of my role.
Right. So
at that moment.
Right. So it sounds like there's sort of 3 takeaways from this exchange. One is the question of confidentiality, which is, we as attorneys are bound by the role of confidentiality, by the obligation of confidentiality. But what we're hearing is, to the extent that we can advise and counsel our clients to go along with or to get help, then that is also our role, advisor/counselor. And then the third thing is this question of setting up services early, identifying resources for our clients. And so let me go there for a second. So Hannah works at the Public Defender Service, where she has a fleet of sort of collateral services, special education attorneys, social workers, and the like. What about the law students in court and the CJA panel? What are some strategies that we might, or you guys might implement to get some services in place, assuming you're not violating a client confidence, assuming that your client is in agreement with your moving forward and helping in this way?
Sometimes we can use the probation officers because, as everyone knows, the probation officer is assigned as soon as they are arraigned or even before they are arraigned. And so many times we will not even be required to get an order from the judge, the probation officer has the ability to provide certain services. They can go forward sometimes with the gains assessment even. They can make the referrals for an educational advocate if they feel like there's a need for one without getting an order from the judge. They can order almost anything that doesn't by law require a court order. Mm-hmm. And so as an attorney, we can work with the probation officer, we can work with the family, we can possibly get DMH involved even without the court, and that's an outside resource for the family. And I'll defer to Mr. Harris for anything.
I think also these days DYRS is also becoming much more proactive predisposition with especially detained children in terms of trying to find services that can be put in place and act as a substitute as incarceration or detention.
Right.
That's right.
And I think that's completely consistent. What we've heard from Judge Broderick is if these referrals need to be made and are going to be made, can we have a healthier conversation earlier in the process? So as soon as our young man is assigned a probation officer, and as we know, under the new structure of probation officers are assigned to the kid within 48 hours and will stay the same. So can we have these conversations with probation officers early? Again, assuming we have permission from our client, assuming we haven't violated a confidence, but having conversations earlier with probation, reaching out to DMH, excellent point, and learning how to navigate that system. Most of you have been to trainings by Jose de Arteaga, who has talked about how to access DMH services, and then it sounds like also who is from DYRS, and then talking to our DYRS caseworkers earlier in the process. So that makes sense.
I wouldn't overlook the community-based services, too. I know that our offender rehabilitation division does a good job of just cataloging them, basically. But DC, there are certainly a lot of holes in services that kids need. But there are more things out there, I think, than people realize. And one of the nice things about DMH and DYRS and Court Social Services lately is that they've been really reaching to the community to get those provisions, and then they don't depend on the case. The child can have them whether they're found involved or not found involved. The kid can continue to get the help they need, which is always good.
Right. And can I ask, and it's unfortunate Judge Josey-Herring had to leave, but whether or not CJA Bar gets paid, adequately compensated for doing these auxiliary services.
She's pulling you out on a limb here.
I am. I think that matters. When we talk about systemic challenges and barriers, is it within the role?
I think most judges are, let me just back up. If there are 50 of us or 55 of us on the court, then there are 55 ways to do it right, 55 ways to do it wrong. So we don't agree about anything. But when we get the vouchers, and the vouchers over the statutory amount, usually that kid's name is going to ring a bell because that kid's been back before me, any number of times. And I'm not going to, and it's just a matter of signing the over the limit letter. So yeah.
That's great to know.
I don't understand that's a problem.
Right. I think in conversations that we've had, sometimes there's been a concern whether vouchers will be cut. So it's good to hear that, there are judges who will sign the vouchers if they are, in fact, doing work related to the development of this child and the representation of the child.
It'll be cut if you never do any work and you always have a huge voucher. But it's not going to be cut just because you spend a lot of time with that kid.
Very true. So just to close out so that we're clear about what the role is, I want to hear, I think Judge Bush started to talk about it, and there's also reference from Mr. Harris about the role of, or the differences between attorneys for adults and attorneys for children. So that's one thing I would talk about a little bit. As Judge Broderick said, there's a little bit more involved when you represent kids, but how is the role different ethically, let's start there, between representing children versus adult, if at all?
I think they're much more alike than different. At least that's the way we try to train the student attorneys that we work with. When we do our training at the beginning of the year, we have a separate training for juvenile at the end, but that's mostly focusing on terminology and juvenile procedure. In terms of how the student attorney is supposed to approach the case, it's almost identical. You are representing a client, you're representing their interests, and again, you leave it to the social workers and the judges and the probation officers to worry about their best interests when you talk about the juvenile cases. So I think that ethically speaking, it's almost identical, much closer than they are in different. I think there is more of a responsibility in terms of counseling, making sure that the juvenile is making informed decisions, but certainly letting them make the decisions ultimately.
I think that when you're working with the adults, it's much easier to get them to understand what's going on with their case. With children, you think they understand, but you must take the time to make sure they understand the words that you're using. For instance, we say delay, and we know that we mean that we're going to address that issue sometime in the future, or your disposition will be sometime in the future. But sometimes kids don't understand the terminology that we're using, and they think delay means something else, and so you have to ask them questions. Do you understand what this word means? This word means this. And also, with the adult, you probably wouldn't do this, but sometimes you need the parents to assist you in making sure that the child understands exactly what it is you're trying to explain to them. And so I think the role of the parent becomes more important with a juvenile. In addition, with adults, it's punitive, and with children, you start off with treatment in mind and rehabilitation in mind. With adults, it's almost the reverse, because you start off with punishment in mind and then treatment and rehabilitation.
Okay. So let me jump in on two things that Wanda Williams has talked about, which is sort of the special role of parents. That's one thing we want to talk about, and then also this question of communicating with kids. So maybe why don't we start with the latter? And I really want to hear if there are strategies that the three defense attorneys have developed for communicating better with kids. And then definitely hear from the judges about what they're observing in terms of that communication. I think we would all agree that it's much harder to talk to kids than to adult clients. So how do we do better at that?
Sorry, you can start
Sure.
with the defense attorneys. I guess, again, I would say a couple things. One is that kids generally, outside the delinquency system, are not seen as decision makers. Adults make decisions for kids. So it's a very hard thing to get the child to understand that he's going to be the decision maker in the case. And then it's very hard to communicate that to all the other adults who also see kids not as decision makers, because in no other arena really do we let kids make choices that affect their health and safety like we do here. So one thing that I do with kids is a lot of repetition. I say over and over again, this is who I am. This is who I am relative to you. Here's my job. Here's what I do. Here's what's going to happen next. And that's sort of how every single conversation starts, even if it's just sort of in a short form. You know, just like you hired a lawyer, and that lawyer, you give that lawyer instructions, you have to always be giving me instructions. I'm going to do what you want. Now, let's talk about what the next choices coming up are. So reinforcing who I am and what the next steps are is critical. And then number two, I find that you always have to ask the kid questions. Mm-hmm. That if you give the kid information and say, okay, or right, kids will always say, uh-huh. And you think, great, this is also perfect. You're understanding everything I'm saying. And if you move on, the kid may be thinking, you know, your shirt doesn't really fit. And you're thinking like this is all like about the plea process and the trial. And so you have to be saying, so what is it that's going to happen tomorrow? So what choices does the judge have when we go in there? So what is it that you think your mom's going to be saying, and why do you think she's going to be saying that? And that's the only way to really hear whether the child's actually comprehending the scope of what it is that you're trying to communicate, rather than just, you know, sitting sort of politely while you communicate it.
Do you want to add to that, Geoffrey?
I think when just in terms of, for instance, working through a Rule 11 inquiry in terms of a plea, to after I explain the questions that the judge will ask and talk about those concepts, then actually run through it for the same exact reason, to make sure that some of this is sinking in and that they have an ability to understand this and make decisions. I think that it's all prefaced, though, by spending enough time with the client. We do have certain advantages over other jurisdictions in the fact that we can take the time to work with the kids and to meet with them. And I try to stress with my students, you never talk to your clients once or twice before you go and start into court and start making decisions with the client. It has to be a repeated process, trying to build up a relationship with them. This is not just to make sure that they understand what's going on, but also they trust you. the more they see you, the more they're going to trust you, the more they will open up and talk about maybe some of the issues that eventually will come in front of the judge in terms of trying to get help for the child as well.
Did you want to add anything?
Just that, what Geoffrey said about the Rule 11 inquiry, sometimes what the child thinks is important is not really important to the case and the elements of the charge, but they have a need to say it, and they have a need to say it to the judge. And it doesn't matter if the defense attorney says, well, that's fine, but that's not important to the charge. We just want to talk about the charge and did this happen, did this happen, did this happen. But it's inside them, and they want to get it out. That's all.
Yeah, and so maybe paving a way to do that by saying to the court, Your Honor, my client would like to be heard. I know we're concerned about this issue today, but my client really needs to express this to the court. And my experience has been often the judges will indulge the child in that way when it's set up and when it's preferenced. I would add a couple of more things, as defense counsel too. This notion of speaking in age-appropriate language and not using compound questions. So not asking more, multiple questions at once and expecting the kid to keep up, but giving the child an opportunity to ask questions to you as often as they need. And the other thing that is really important is using visual aids. I've really started with our students creating charts. So if I've got to make a plea decision with the kid, what are, you tell me, have the kid construct, my students are laughing, having the kid construct for themselves what some of the benefits are of going to trial in this case, what are some of the benefits of taking the plea, and the kids really get into it, and so they own the decision. It's sort of what Hannah's talking about, empowering the client to understand that they actually can make these decisions. So that's one thing we've begun to use. And I'd ask the judges whether there are things that you're observing that could be better in this regard. Or
one thing that I've observed is that we do take a lot of pleas. And one of the things that we always do is ask the defense attorney to put the plea on the record. Mm-hmm. And they always say, government waive step back with their allocution, and they won't oppose. And they ramble on. And you look over at the kid, and their eyes are glazing over, or they're looking at the clock. They don't have a clue what the lawyers are saying. So I know that the lawyers are saying this to be expedient and that they've probably explained it to their clients. But I don't know for sure that they've explained it to their clients. And this is their plea proceeding. This is their moment in court. They should understand everything that's going on. So I frequently will go over, I always go over it with them again, and I don't know how well I do, but I do try to put it into childlike language and talk with them a little bit and make sure they understand. But I think it would be helpful if the lawyers, during the plea process, tried to talk in a language that their clients understood.
Wow, that's good.
There's one thing that Judge Broderick taught me in her courtroom. I had a plea once, and there was one detail left off the plea form, and which I thought was a minor thing, but it turned out to be something that was important, and it was important to the court, and it was important to the child. And so I think that sometimes we do that, and we just write it up, and we just put the basic things on there. But I think we need to go into more detail with our plea forms, and we need to put the entire agreement on the plea form so that the court understands, and we can make sure that we've gone through the whole thing with the child, and that the government and the defense attorney are all on the same page, are both on the same page.
That's good. Okay. And I guess one other thing that you made me think of is this notion that each judge is a little different in the plea colloquy. And one of the things that we tell our students too is go to court and watch that judge, because it's different. And so when you do this rehearsal that Geoffrey Harris has talked about, it's about doing it in the way that Judge Bush is going to do it, or in the way that Judge Broderick is going to do it, so that there are less opportunities for the plea to break down, or for the kid just to be confused, which is really what it's about, making sure the kid understands and is doing what the kid wants to do.
And one thing that's helpful, because I don't see your conversation with your client, but you probably have had a more extensive conversation with your client than I have, especially early in the proceedings. And so if you know that your 13-year-old is not as verbal or as quick to pick up, or has a learning disability and will be challenged more than your typical 13-year-old during the plea, you don't have to embarrass the kid. And I'm not a huge fan of approaching the bench, and you know this, but for that one you can come up and say, Judge, this young person is going to be challenged, and could you please go through this as slowly as you can. And then that lets me know, and I'll because I don't go that, I hope I don't go that fast, but I'll even make more of an effort to take little steps with the kid.
All right, so let's then talk about this other issue, which is the role of parents in all of this, which all of us who practice and represent kids, we realize that one of the big differences between representing a child and representing an adult is that the family is way more involved, right? So, and that oftentimes complicates things given how we have articulated our role as defense counsel. So I wanted to start off with the defense bar again and asking, how does the role of parent, or how does the involvement of parent complicate things, if it does, and what are some strategies for handling that?
It absolutely complicates things. You can only imagine the looks that you get when you go to a parent at that first court hearing. You go outside JM15 and you explain to them, I represent your son, I don't represent you. And you can see all the bells and danger signs going off in their head, like, who is this guy? He's just some other dude from the system about to tell me how to raise my son, and I don't need it. And I need her. I really need her when I go into JM15. And I do not want to be starting off on the foot where she doesn't trust me and isn't going to trust me when I then segue into why it's so important that the child go home with her today, and that she doesn't just sort of teach him a lesson and let him stay over for a week or 2 weeks or whatever it is that she's got planned. So you do have to, or we have to finesse it quite a bit, and it is complicated, but I get the sense that you're honest, you, in as delicate and polite a way and deferential a way as possible, you explain to the mother that you're representing her child. You can do everything you can to get the best outcome for that child. Sometimes there may be conflicts. She'll understand, of course, that you represent her son, and you're going to have to represent his interest when those conflicts arise. But absolutely, I try to cultivate the mother as an ally. And I do this, I explain to them that as a parent myself, I understand that it may not be so quick for the kid, but soon enough this case is going to be over. The child's going home to their mom. It's going to be mom for the rest of the life. And so I'm not here to interfere with any kind of relationship. And I think that can often win over the mother and calm them down a little bit and get them to accept the idea that just for now, you're representing the kid. There may be these conflicts, but we're all going to try to work around them. And usually that can work out. Now, a lot of times, you have situations where the parent is actually a sort of divisive influence on the child. And you do what you can. I think sometimes you have to try to isolate the parent. Sometimes you do approach the bench and you try to explain to the judge that I got concerns about the mom based on X, Y, and Z, just to sort of, try to alert the judge to the situation somewhat. I think one of my favorite cases that I ever tried was a case where my client was accused of threatening his father with a gun. It actually went to trial. The child was detained. Judge Bowers, bless his heart, found the child not involved. And at the end, the father in the courtroom was like, wait a minute, what does that mean? He's coming home tonight? But, it works out. You have to... I've taken over cases where other attorneys had started working on the case, and I've had the parent complain about their relationship with a prior attorney. I think oftentimes when a client suggests that they want a new attorney, it's actually coming from the parent. And normally I'm able to work through the situation. So I think it's just a matter of being delicate, but at the same time letting the child know, even if it's a matter of doing it privately, hey, I'm 100% behind you. I'm going to tell your mom what I got to tell her to make sure that we can get you home.
The other thing is if the parent doesn't buy into the conditions of release, most of the time the child is not going to buy into the conditions of release. And so you do have to work with the parent to get them to understand what the child is supposed to be doing. A lot of times, too, it depends on the age of the child. It's especially important with the very young children. And sometimes, as attorneys, we have a child who we think the plea may be in their best interest, or it may be what they want, and then the parent is at odds with the child because they don't want the child to plea, because they never believe that their child has done anything illegal or wrong. And somehow I think we need to get the parent on board. It's easy to say, well, it doesn't matter whether the parent is on board or not. The child wants to plea, that's all we need to know, and we could just go ahead with the plea. But then once the plea is done, like Mr. Harris says, then the child goes back home with that parent, and the parent is the one who is charged with monitoring that child and to assist them in following whatever conditions the court sets down. And they're not going to want to do that if they haven't invested fully into what we're doing as defense attorneys.
Right. So the challenge is buy-in from the parent while simultaneously not violating the loyalty of the child client.
Right. That's right.
Hannah, did you want to add anything?
Well, just that this relationship, I think, or navigating this tension between your absolute attorney-client obligations and what the parents' needs are and the importance of the parents to your case mirrors our earlier conversation about getting services, where the lawyer has to know who the client is and whose interests the lawyer represents. And the lawyer has to be extremely clear, for example, with the parent, that the lawyer does not give that parent legal advice or represent that parent in any way. But having said that and knowing what those rules are, a parent is completely critical to the child. The parent has been the decision maker every minute until right now. The parent is the placement. Whether the parent's healthy or not, it's the child's parent and the primary attachment that the child has. So you need to make the boundaries clear to everyone. The child needs to know what your role is, but then you say to the kid, we should talk to your mom about this. Your mom should be giving you advice about whether to take the plea or not take the plea. Either you and your mom need to come up with a set of conditions that you guys can both live with if you come home. So I think it's sort of similar in the sense that there are tensions where you could just go to mom and be like, I don't represent you. I'll see you in half an hour after the hearing. But that ultimately is going to be completely destructive to what the kid's goals are in the case, which is usually release and a good relationship with mom.
Do either of you have anything you want to add, Judge Bush and Judge Broderick, in terms of what you've observed about parents?
That's a whole...
It is a whole conversation. We could have a panel just on that. But
I just understand that the judges know that tension and that distinction, and we can appreciate when the parent is blasting you out. It's not because you're an idiot, but you just really pissed them off and you just disagree, and the kid disagrees with what they want, and don't feel self-conscious about it.
And I guess the one thing I would add to the conversation is this notion of getting buy-in from the client. I mean, from the client's family. And one of the things that we have found really successful, DMH, DYRS, court social services, as we are raising the level of services that we provide in this community to our kids, we need to be educating the parents on what's out there. And so when we go to detention hearings and parents are saying, I'm not taking them home, I've had it, this is ridiculous, we send our students out in the hallway to sit between the child and the parent on one side. Let's read through the book, the detention resource, Alternatives to Detention book, and figure out what resources might be good, that you two can agree on to put in place. And oftentimes the parents will change their mind. We'll have parents who went to court social services and said, you know what, there's no way I'm taking the kid home. And then we talk to the parent out in the hallway, get them to change their minds. They go back, tell the probation officer, you know what, I have changed my mind. If I can get this service in place, then I'm willing to give it a shot. And so the task for us is to make it work, which is what Judge Broderick talks about. Don't just let it go there. So you've convinced the family to take it home. The next step is following through on the referral. So if the kid is going to go to a third-party monitoring program, did we call within 24 hours to that third-party monitoring program to make sure it actually was put in place? And we know Judge Broderick.
Thank you for saying that. Because if I have one objection, it's that people say, yes, Your Honor, and they walk out of the courtroom, and nothing happens until the next time they walk in the courtroom.
Yeah.
And that's where I think there's the big gap.
Right. So follow through from us as defense bar is a critical piece. So let's move for a second then to talk about what some of the strengths are in terms of the defense bar following through with the attorney practice standards, and then just really quickly identify what some of the things are that we need to work on as a defense bar. Do you all have thoughts about what's going well with the juvenile defense bar in D.C. as a starting point?
Are you looking at me or her?
Either, all of you. This was an all
shorter answer.
I usually say defense bar or judges, but no.
No, I mean, I've already put in my point. I really do think that it's invaluable to have experienced counsel. Now, I don't mind having students come through with their attorneys because they go the extra mile and they work so hard and they take it so seriously and they just put everything into it, and that's great. But
things to work on, I think, is coming.
Except they're not available on Tuesdays.
And I guess it would be my preference if that having experienced counsel carried over across the board, but things are as they are. But yeah.
So you would like more experienced counsel? Okay.
Mm-hmm.
Okay.
I mean, I guess, we put our new lawyers in juvenile court. But we do put in lawyers who have experience, in the sense that our lawyers come to juvenile court with an 8-week training behind them and supported by ever-present, sometimes too-present, supervisors. And I could go on about the strengths of the defense bar in D.C. forever, but I've lived all over the place, and I've practiced law in a couple different places. I've never seen lawyers, PDS, the clinical programs, and the CJA bar, who take the success of their clients so personally. So when I read the attorney practice standards about, you go to your client's house, you know their parents, you know where they go to school, you investigate both the facts of the case and character witnesses as well as mitigation for disposition. I think we could certainly improve, but we do these things. The attorney practice standards, to me, read like a checklist of what the lawyers in my unit do in the first 24 hours and 48 hours of a case. Because it isn't just, we have these criminal charges, we're going to try to beat them, and that's the end of it. I mean, these kids stay with us. I had dinner not too long ago with a client of mine from 8 years ago, which is making me very old and her shockingly old. So, in terms of really investing in the holistic representation of children in the district, I think we're doing a pretty good job of that.
Yeah. I think one thing I would add, and I see that Stephanie Harrison is in the back, that one of the things that's happened since June of 2004 is the increase in the number of trainings that are available to defense bar. And one of the things that a number of us have commented on is how well the CJA bar attends those. And even when folks have all their CLE credits that they need, folks are still coming out. So that's another thing that I think is a tremendous strength. And the programs that the D.C. Family Court puts together, folks are coming out to those. So I think that's another tremendous strength. I think we take advantage of the fact that we have small caseloads compared to other jurisdictions. So in terms of students and in terms of the public defender service, they really don't just work 9 to 4 because they have a smaller caseload, but they're going the extra miles and going the extra mile to work on behalf of kids. So I wanted us to start there in terms of some patting ourselves on the back about what we're doing well, but then the next question is, which Judge Bush has begun to talk about, but what are some things that we as a defense bar can do better to raise our level of practice and to bring us even more in compliance with the attorney practice standards? So if you have thoughts about that.
I also have thoughts about that. I don't want to monopolize it, but I always feel like we could treat the delinquency case more like a criminal case. When I go to the adult courtrooms and I look at how cases are litigated and the motions that get filed and the trial practice skills of lawyers who practice in cases equivalently serious in adult court, I always think we could do a better job of that section of the case. Not that just the services and the disposition and the case planning, but this is a system in tension and there are two parts. And I always think our knowledge of evidence and of criminal law and procedure, that's sort of the area that I wish that as a defense bar we were a little better at.
So would there be benefit to additional training specifically around rules of evidence and trial skills, or I'm getting some nods over here from
I think we could see some improvement in trial skills.
Mm-hmm.
I think that because it's not a jury, people are a little bit more lax, and I see a lot of things going by that could be objected to and aren't, for example. Mm-hmm. And I think a little more effort could go in sometimes to the representation.
Right. So there would maybe some value to some trial skills workshop. Stephanie Harris and I have definitely been talking about potentially setting something like that up. So that's interesting. Other thoughts?
At the risk of just simply repeating what Hannah said, I do think that we have to keep in mind that as a defense attorney, part of our job is sort of put the brake on this rush to disposition. There are very well-intentioned people whose aim is, let's get the services to the kid. And of course, the first step in that is we got to find the kid guilty. and then we have the full authority to get these services that these kids really need put in place. Part of there's a impulse, I think, on all the parties to sort of co-opt the defense attorney into that and say, come on, the idea is let's help these kids. And let's not litigate the Fourth Amendment issue. Judge Byrd, when one of our students came in with a Fourth Amendment issue, said, you know, you all are filing entirely too many suppression motions. What is the deal with the suppression motions? Oh no, we got to step back a little bit and begin again. But there just does seem to be a systematic rush to disposition, and part of the problem with that is that it doesn't necessarily mean the kid is going to get top quality services. One is, at best, they may wind up in the community not getting great services. The other is that if the kid fails out of services, fails out of his probationary period, for instance, because he's involved in the same activities that got him into the system in the first place, well, now he's not getting the services. Now he's going to Oak Hill and he's sitting in the detention center. And all that great intentions that we had at the beginning of helping this kid, now we have a child who's being victimized in a detention center, with the hope that maybe later he's going to get some services when his behavior turns around a little bit.
I guess that's a place where we disagree, because I don't think you have to find somebody involved to start giving them services. It may be the type of services. There may be some question there, but I think some services can begin before you find the kid involved. And I think if the kid knows that this is a system that, yes, we're going to have an adversary process, but not all of it's adversary, and you can work on yourself at the same time, I think that's a positive thing. I don't think we should tell them to absolve themselves of all responsibility for their lives simply because they haven't been found guilty of a crime yet. One thing, though, I do agree with, there should be more motions to suppress. I don't see too many of them, except by the students in PDS.
So more motions to suppress, and again, it goes back to the early referrals for services. Again, so long as your client is in agreement, then why not get the services started while you're in the system and the like.
And if I could just say, I mean, there's tension everywhere, and there's a tension between getting things done efficiently and moving cases along and meeting the 30-day and the 15-day and the 45-day and the 60-day and all that. And that's fine. That's true everywhere, and that's not going to change. But, yeah, the services, I've sat in JM15, and I start ordering services in JM15. And I don't do it because I assume that person was involved. And I get orders from JM15 where services have been ordered from JM15. And I know that magistrate judge who's sitting there isn't doing that because they assume that kid's involved. And I do think that having gone to trainings in other jurisdictions and other family courts, I think our kids get due process. And I don't get pissed off at you because you file a motion. And if I'm annoyed with you, it's probably not because you filed a motion. And I, believe it or not, have trials where I find the young people not involved. And I can look around the room and see any number of lawyers who've had trials before me where the young person was found not involved. And I wasn't mad about it because I don't get to send this kid to wherever. Heck, I got a zillion kids. And by the time you get to trial with me, I've already ordered anything anyway. So I don't care.
I think that overall we have a very good defense bar. I think they're very knowledgeable. I think they care about their clients. They care about the proceedings. They're not all perfect. We're not all perfect, but we do try and get everything done. We're working with some constraints ourselves, especially with the 30-day cases. Everything that we do is tied to a voucher. And so if we don't get our voucher right away, then we can't order our transcript. We can't get the investigator on board. And so the process for us may take a little more time to pull it all together. So we're working really quickly to get it all done in 30 days. And I think we do a good job in getting it done in 30 days or 45 days, considering the constraints that we have. Everybody has room for improvement. We can improve on filing our motions and getting everything in. Sometimes it's a strategic move not to file the motions, but I think that's up to the individual defense attorney. And I agree that some training on the rules of evidence and hearsay would be wonderful.
Taking notes, Stephanie? Right.
And on that point about the voucher, if you believe that it's gotten lost somewhere in the system, don't hesitate to call Chambers and talk to the administrative assistant of the judge, because I know that when I get the whatever the little thing is called where you plug it in and pay the voucher thing.
Right.
I look at them the first day that it comes up on my email, because it's all done electronically.
We get a little email
So
that is saying
don't
no
assume that the
vouchers.
judge is sitting on it because they want to. Probably something has happened if it's not being expeditiously processed.
Well, we're supposed to get our voucher within a couple of days of arraignment, and we don't. That doesn't always happen. It doesn't always come from finance in time. And everything is tied to the voucher.
You're talking the appointment voucher, the initial voucher that, right.
Right.
Okay.
Right.
Okay.
Right.
I actually, while I'm waiting for cases to come up, I actually sit in court and check vouchers and do vouchers, and I try to get them out within 24 hours so they're coming on my system.
I think an initial appointment voucher, I mean, at least from what obviously this is a luxury that I don't have to worry about this, but one thing that I've heard is that the very initial one, not the judge approving it, but the initial one delays a little while, and then there's a problem with investigation. Because for us, it's our practice that the best investigation you can do happens in the first couple of days of the case coming in, because it's before the fence has gone up or the neighbors moved away or people forget what they saw. So if you have to wait 3 days to get your voucher, and then you have to put in for an investigator, and then that has to get approved, and then you don't get an investigator for that time period, I think that's a real impediment to effective investigation.
Right, because the investigative voucher is tied.
I just did a couple of pre-approval vouchers before I came here.
So it's different, though. So what this actually, the judges don't even sign off on those. If I'm not right.
But can't you do up to $350 worth of investigation without approval? Can't you?
You can, but you can't get the investigative voucher until you get your voucher, because it's all tied together.
Okay.
You can't even request the investigative voucher from finance until you get your attorney voucher. It's all, and you can't request a transcript. You can't do anything until your voucher is in the system. Your initial voucher.
So that's a huge issue, though. That takes us into exactly where we're going, which is pointing out some of the systemic barriers. And I know we, who've sat on different committees, have heard that repeatedly, this notion of the problem with the vouchers, not the initial appointment vouchers, which then throws CJ off entirely for the rest of the case, is got to be dealt with. So if there's a way to take that back to the appropriate committee, then that's something that should be addressed. I also want to respond to the other vouchers, which are transcript vouchers, other vouchers that the judges are actively involved in. Not all judges do them expeditiously, and we're very clear about that from just conversations with judges on the bench and the like. So I guess our request certainly would be from the defense bar if there would be training or the like, or reminders that the vouchers have got to go quickly, particularly now under the 30 and the 45-day rule. So it's just sort of anything y'all want to add? So the other thing that we want to talk about in terms of systemic barriers or obstacles to zealous advocacy, are there others that are a problem? It sounds like investigation is a problem because you're not getting vouchers to hire an investigator. Now, it's worth looking into what Judge Broderick is saying, which is up to $350 worth of work before it's approved. Are there other barriers at the pretrial phase or the trial phase that sort of get in the way of what we're called upon to do?
One of the issues that our students are most surprised of, I think, is the level of hostility between them and the prosecutors. And I don't know if we could do a training on just sort of basic civility. I mean, when we're not trying to bring the system to a grinding halt by filing these frivolous motions, and we're trying to work something out with the prosecutors, the students are surprised at either the level of acrimony involved. And then sometimes it's not an issue of that at all, but just that a prosecutor hasn't been assigned yet, or they don't have to file, and so nothing happens. And we show up for status, and the day of status, we get a plea offer, and people are hoping, I guess, that we can sit down and talk to our juvenile client in the 30 minutes or so that we have before the judge calls the case. Hey, let's go over all this stuff now. Let's talk about it, and let's have you make an informed decision. And that just doesn't happen. So I don't know if there's sort of a combination. One is just a matter of, sitting down, why can't we all just sort of work this out, get along? And the other part is, and we have nothing to do with this, I guess, but trying to get the prosecuting office to get a little bit more on the ball when these cases come in.
In terms of discovery, in terms of responding to...
In terms of discovery, in terms of just having a jacket available so
Oh.
they can have a discussion. I have a case up for trial on Thursday, and I don't think it's been assigned yet. I can't get a
that's
prosecutor
interesting.
to return my call.
So, I mean, maybe that's an idea in terms of what are the takeaways? Maybe we can do another program instead of a conversation between the bench and the bar. We have a conversation between OAG and defense bar and figure out how we can, truly work through some of these issues. It's not a bad idea. Other thoughts about systemic barriers? And you don't have to limit yourself to the trial phase. What do you think is getting in the way of zealous advocacy?
Well, when I was thinking about it in preparation for coming, I think about it in terms of two categories, I guess. One is pace, and one is the paradigm. So pace, juvenile cases move so fast. It's just amazing. The fastest case is in adult court. I know you think that I move really slowly.
No, that's not it.
But, and I guess in some ways, I take that as a compliment. But the fastest cases in adult court are 3 times or more as long as these juvenile cases, and the charges are the same. Your carjacking in juvenile court is just flying past you from the minute you get the kid. The clock is ticking in terms of the investigation, the discovery, the motions practice, doing your own trial prep, developing a relationship with the kid. I mean, it's just unbelievable how fast it is. And to a large extent, the problems in that pace category are necessary problems, because kids, they have less life. Every minute means more in terms of how long they've been alive and their thinking and what's happening to them in detention centers. So to some extent, that has to exist the way it does. Now, there are certainly things that we could do to speed it up. We could have rigorous timelines for what our own expectations of ourselves are. We could certainly light a fire under the OAG to be assigning prosecutors, responding to discovery requests, giving us the videotapes and stuff so we can talk. But generally speaking, pace is a necessary problem. Paradigm is not. We have a bad situation right now, I think, in the district in terms of, I don't know if it's public perception, but perception outside the defense bar of the defense bar. This idea that we're, that we don't care about the kids, or we don't care about rehabilitation, that we're just out to win, and that we're unethical in terms of the way we conduct ourselves in the service of winning. And this situation has been a real decline since I started practicing here about 9 years ago. So, and there are some easy things to point to, that are pretty easy fixes. One is we don't have a good communication system in terms of discovery with the prosecutors. So, we get some discovery at the initial hearing, but there are these weird games about, in JM15, we have to do the PC hearing before we get the discovery. But they're sitting there with the discovery in the file to give to us. They just won't give it until we're done with the cross-examination, which means meandering, longer, less efficient cross-examinations. And then when they give it to us, it's redacted. The public documents that we would otherwise just be given at a police station are redacted to create more work in terms of going to the police station just asking for the document that we're allowed to get. So there's this weird sort of scavenger hunt competitive mentality that isn't really about the true adversary system, but is sort of about, sort of blocking the efforts to do what is our job and our obligation and responsibility to do. So that, I think, could probably be fixed. Then there are some things that are harder that are just about, at least the way I experience them, the perception of what our role is, the appropriateness of us investigating our cases, the appropriateness of talking to people who have been victimized by crime, the appropriateness of talking to coworkers of victims. And we have real obligations and responsibilities. In order to do a good job in our cases, there are things that we have to do in every case. And I guess I feel like when I started 9 years ago, it was an adversary system. The prosecutors didn't love it when we did it. They would do their best to prove their cases. We would do our best to help our client be acquitted. But everyone sort of seemed to say, this is your job. We like that you're here. We like that you're zealous. You're making the system run efficiently. We expect that you will do this, and that way we trust that the defendant or respondent is getting what they need. And I feel like more and more prosecutors have started to question whether or not we should be doing that, whether we should be talking to child witnesses, whether we should be talking to, going to the house and knocking on the door of someone who's reported a crime. And that I think that's been a real problem. And it's one that I'm not sure exactly how to get at it. I've always sort of prided myself on having a good working relationship with the line AAGs and with judges. And for the most part, that's still true, but it's getting a lot harder. And for new people coming into the system, the expectations are a lot different, I think, than they used to be.
Is there any response from either Judge Bush or Judge Broderick on that?
I'll go ahead and put my witch hat on. As long as the ethical standards are followed by your investigators. And I have parents coming in and I have witnesses coming in, and they will say, and maybe there's a lack of communication. Maybe they weren't listening carefully, or maybe somebody in your office slipped. But your investigator should be saying, this is who I am, and this is who I work for.
Right. So we do. I mean, in large part, because it's when we have our ethical responsibilities, we follow them. And in large part because our statements that we get from witnesses are only as useful as the fact finder finds them. So when our investigators go, I mean, part of what their testimony generally is I show my PDS ID. I say this is where I work. I have them sign an ID of investigator form. And at the top of the statement, it generally says, taken by the investigator who works for so-and-so attorney on behalf of so-and-so client. And this is actually a perfect example. When I first started practicing, when I'd use a statement like that, the witness would say, I didn't know who you were. You told me you worked for the government. And I'd say, well, it says here on behalf of so-and-so worked for so-and-so. And the witness would say, well, you lied to get me to make this statement. And at least my memory is, that both the judges and the prosecutors sort of understood that witnesses often regret having talked to us, and they wish that they hadn't. And the way that they express that or experience that is to say, no, I didn't understand. Just like my clients, after having confessed to the police, are like, oh, I didn't know who they were. They were going to let me out of jail. I would totally not have done that if I had understood the consequences of doing it. But I guess we had more, I don't know if the word is credibility, but the expectation was that we were not out lying to people and pretending that we were police officers when in fact we do have this sort of...
I'm not sure the same care goes into making sure the witness understands who you are as goes into making sure your client understands who you are. And I do find it somewhat offensive, and I know it's your job, when young witnesses, 10 and 11-year-old witnesses, are interviewed by more than one person coming with a government badge, and their children, and they're either interviewed alone or their parents are told to leave the room. I have concerns with that, and you can say it's ethical and you can say it is, but I'm the one that's going to have to judge how that child responded, and I have concerns with that.
And you have to keep in mind, and I know Judge Broderick has told you, has made this point before, and I agree with her that, you know, you're only credible once, and the presumption is that you're telling the truth. But when you come into court and you shade and you shave and you come back around, and if you convince me that you are not an honest person, then when that witness takes the stand and said, no, you didn't tell me who you were representing, you didn't tell me who you are, why should I assume that you are telling the truth now and that person's being, you know?
Right. No, I understand that.
Once you lose credibility, it's gone.
Right. Well, I definitely understand that. And I guess I have two responses to that. One is, I hope that we behave credibly and ethically in all things, because it's important to our jobs and it's important to the outcome of our trials, and it's obviously important to the continued relationship with our fact finders. Maybe I have three things to say. Number two is, I just hope that in a situation with a defense attorney who you don't know and a witness who you don't know, that they're at least getting equal benefit of the doubt. Well, usually, yes. Although we do start a new class in juvenile court every year, right? So you may or may not know the particular
but
attorney.
By the time you get to trial, I know who that is.
Right.
It's not the first time addressing me.
That's true. But so there is some of that. And then I guess the third thing I would say is, we, generally speaking, investigate in ways to protect the outcome of our investigation. So we do carry PDS IDs, and we do often send people in teams, so that if there is a question later about sort of how that interaction went down, there can be a second person to vouch for, this is what I saw, this is how it happened. So, but this is one example that does come up all the time, in terms of what the expectations of defense counsel are. So, you know, we do, in the attorney practice standards, I was looking at them and I was reviewing some cases in terms of coming here, ineffective assistance of counsel cases, in terms of what our investigative responsibilities are. And they are wide and they are deep. You know, so the interviewing the 10-year-old, it's a very difficult thing to do. And generally speaking, we won't ask an adult to leave the room unless there's some problem with the adult and the child both being witnesses in the case. And then we will say,
oh, no. That's just not true. I'm sorry. That may be true most of the time, It's not true all the time.
It is. I don't mean to suggest that there has never been a circumstance ever where we have said to an adult who's in the room, look, here's the problem. Here's what I'm trying to do. Here's the conversation I want to have with this child. And here's the reason why. But it's always the choice.
I'm a lawyer, and I want you to leave the room. And so, oh, you're a lawyer.
Well, I mean, I wish in some ways that people were that responsive, and I can't speak to the specific case because it wasn't my case. But I will say that when we go into people's homes, in theory, like when the police go in or when the prosecutors talk to their witnesses, it's always they have a choice to talk to us or not. You know, we knock on the door, we say who we are, we say why we would like to talk to them. Most of the people whose doors we knock on say no, I don't want to. And then there are people who do.
Just so that we all get along and everything's just if the investigators could be very careful in talking to people to identify who they are, not just to the witness that they're looking for, but the people surrounding. Because I had this lady who was brutally beaten. And your investigators look the way they look, and they're young, and they're dressed very casually, and they show up, and they don't say who they are to the neighbor, and they say, hey, where's so-and-so? When's she coming home? And they sit outside the house and wait. That person finds out that there was some really young person dressed like whatever, sitting outside their house waiting for them. They're terrified. And all that investigator had to say was, I'm an investigator. I'm waiting for your neighbor. Could you tell me that? And that person's not put in fear for their safety.
I've also had the experience of being in trouble for telling the co-workers, actually in this instance, of a victim, that the person was a victim of crime. I'm here to talk to them because they were involved in something, and I want to talk to them about that. So it is a complicated. There's certainly no obligation, I think, to identify yourself to people that you're not talking to in terms of investigating the case. I mean, I am familiar with that case, and I do think it was regrettable that the woman was as afraid as she was about what happened. I also understand that she called the prosecutor. The prosecutor called us, and we said this is who it was, so that she could get that question answered for us.
You guys, I hate to cut this off because this could go on forever.
Sure.
This is the kind of conversation that at least is healthy. There's disagreement, but it's healthy so that we at least begin to work through what the issues are. I mean, I think the takeaway is, and I don't think the defense bar disagrees with this at all, nor has Henning in this exchange, that the training is we carefully identify ourselves, who we are, what our role is, and why we're there. Whether it always happens or not, you know, we can't say, but that's certainly our intention in training, and we need to reinforce it, and we will do that. At the same time, though, you know, our request as defense bar of the court is understand our role, which is to investigate, and that it includes some very unfortunate things like interviewing witnesses.
We're concerned with the manner, not with the...
Say it again?
We're not concerned with the fact that you're doing it, we're concerned with the manner.
How, right. And so we need to get on one accord about that. And, you guys, I would love to continue this conversation, but we want to hear a few minutes from Gault, who we have all come out to see. A lot of people have asked me questions about, you know, what is Mr. Gault doing? You know, folks are very, very excited. I see people have not left. People are here. And even people in the back who are close to the booth have not left. People want to stay. And so what I want to do is, because one of the things we really wanted to do was get solutions, and some of them have come out. I've taken some notes. One of our students has taken some notes. I'm sure Stephanie Harrison has taken some notes. But our guess is that there's more suggestions. And so what's happening is you've gotten white note cards. If you have suggestions for things we can do to raise the level of practice in D.C., we would love to get those suggestions, and we'll collect them and get them to the people, you know, to the right places. So we want to do that. So I want Gerald to come on up. Thank you. Gerald Gault is actually one of my favorite people, and he's why we do the work. So what I figured I would do is just ask Gerald some questions to draw out a little bit about his experience, and then he'll tell us a little about himself and why he's here with us today. So just to remind people of sort of where Mr. Gault situates in the case, obviously, as we all know from reading the opinion, that Mr. Gault was arrested back in 1964. Arrested is a very loose term. In fact, the sheriff came to his home and took him away while his parents were not there. He was never given a lawyer. His parents weren't notified of where he was. His parents got home and they went looking for him. And then they found him. And that's sort of how this all got started. So we wanted to ask you some questions that people have asked me. As soon as they hear that Gerald Gault was coming, they start asking me questions. So one of the first questions that I always get is, what was it like for you when you were taken away that day without your parents being there?
Oh, it was devastating. I mean, 14 years old. I've never been away from my parents. I mean, and you don't know why you're being taken away. You don't know where you're going. It's devastating.
Did you know what a lawyer was back then when you were 14 years old?
No. I mean, 14-year-olds weren't supposed to know what a lawyer was. That's what parents were for, you know? Well, 14-year-olds didn't need attorneys, according to that judge.
Right. So where exactly were you taken when the sheriff came and got you?
County drunk tank.
The county drunk tank. So tell us what that is.
County drunk tank is just a square little room with concrete bunks. And it's where they put the drunks.
Drunk tank, literally drunk tank.
Yes. They put the drunks in there to sleep it off.
I see.
Well, then they did.
And was that for adults or for kids?
That was for adults.
And
Us kids didn't drink then.
Sure.
Well, I know I didn't.
So how long were you there at the county jail?
Well, whenever they picked me up was early in the morning because I was getting ready to go to my very first job. And whenever we left there, it was dark.
So you were there the entire day?
Something else that I don't know if it still goes on. I pray to God it doesn't. But from the time I got there till the time I got into the actual juvenile detention center, I got no water, no food, and there was no bathroom facilities in there. I mean, there was nothing in there but a steel door and concrete bunks.
And I take it you didn't talk to your parents?
Oh, no. No.
And then at the end of the day, where did you go?
They took me to the actual juvenile detention center there in Globe.
And how long did you stay in the juvenile detention center?
Oh, it was about a week or so that I can remember.
Do you remember what the juvenile detention facility was like? Do you still have it in your head?
Oh, it'll never leave. Yeah, it was a building, you know, I mean, with bars on the windows. And you had the cell that I was in was I call it a closet. Because my wife has a bigger closet than that room. With 2 bunks. And one of the jail type sink potty things. And that was it.
So, so when did you actually go before a judge? And what was that like?
See, my dad was working up in Grand Canyon, so excuse me. It must have been about 7 to 10 days.
And describe that. Was it like the courtrooms that you see today, or was it some other kind of place that you went to meet with the judge?
No, it was his chambers, I guess. I mean, it had a desk in it and 4 chairs.
And who were the people who were there? Were there 4 people there, or were there more?
Yeah, there was the judge, me, my mother, and my father.
Were there any witnesses?
No.
Any lawyers?
No.
And what were you thinking while this hearing was happening?
Oh, just, he's going to tell me what I did wrong, and he's going to slap me on the fingers and send me home with my mother and father.
And that's what you thought was going to happen?
Oh, yes, yes.
And what did end up happening? What did the judge decide?
Well, he decided that I was a juvenile delinquent and that my parents weren't doing a job raising me, which was a lie. That I was going to the state reform school till I was 21 years old. 6 years.
And remind folks what you were accused of doing.
I was accused of making lewd phone calls to some lady there in Globe that I now know was, if I would have been tried as an adult, which they didn't do then either, I would have only gotten a $30 fine or 30 days in jail. I got 6 years.
6 years without a lawyer, without
Right.
a parent, without witnesses. So We know that from the case that your parents weren't happy with how all of this
No.
So tell me, how did your parents react to this case?
Well, whenever, what really set my father off was my mother asked the judge if she'd kiss me goodbye. He told her, no, you don't deserve that right. My father stood up and said, this is bullshit. And believe it or not, I got to see my mother, but the only thing I saw of my dad was his back going outside. And he was not happy. I found out eventually that he went to an attorney right straight from there. Left my mother walking. Oh, yes. And went to an attorney. And he told him he couldn't help me because he was an adult defense. Anyways.
A defense lawyer.
Right. So he sent my father to Phoenix. And I guess he's seen 6 or 8, 10 different lawyers. And finally one says, well, you know, I got just the lady for you, but you have to go over to the ACLU to see her. And because she works part-time there. And he gave my father Amelia Lewis's card. God love her. But my father only had $100. And she says, well, that isn't going to be enough. He goes, that's all I have. She goes, that's all you need. But I'm telling you, that's not going to be enough. She took the $100, and as you can see, the rest is basically history.
Yeah. And how did you feel when you found out that your case had made it all the way up to the Supreme Court? What did that mean to you back then?
Well, I was in school in the Job Corps Center at Parks Job Corps Center in California, and I was doing something I wasn't supposed to be doing because I was sleeping. And they come up and told me, hey, you need to go up to the main headquarters. I says, oh, man, now I'm in real deep trouble because I was sleeping whenever I should have been in class. And so I go up there, and the dean of boys there says, do you know you won your court case? I go, I had a court case? What court case? I says, I don't remember of having a court case, so, you know, I didn't do anything wrong to be in court and that, so what kind of court case are you talking about? And he told me. It was from whenever you was a kid. Damn, I ain't nothing but a kid now, but he says, oh yeah, you won the United States Supreme Court, and the Supreme Court decided in your favor. And I says, really? It was exhilarating, but yet it was a relief. You know, I'd already tried to get on with my life, you know, and now that this was happening, now I could get on with my life. Maybe now I could get a job, keep a job, you know, because if I got a job the minute they found out that I was in the reform school, I was gone. I had a job at Kennecott Copper Company, you know, that they found out that I was in the reform school, I was gone, you know. So then whenever you were in a reform school, you were targeted. I mean, it was just like an adult, you know. I mean, you're bad. We don't want you. We don't need you. No matter what it was for. I mean, it could have been for chewing bubble gum in school, but you was in the reform school, you're no good. You laugh about that. There was 7 and 8-year-olds in the reform school. 7 and 8-year-olds. A whole house full. Okay? Of 7 and 8-year-olds. Why? 7 and 8-year-olds in a reform school? I didn't think it was right then, and I still don't think it was right.
So that actually brings us to our next point. So why are you here? Why did you agree to fly all the way out here to the East Coast to come and talk to lawyers from D.C.?
Well, they might be lawyers from D.C., but they represent all the judicial public. And if I can motivate or inspire one person to go that extra step for these kids, it's worth it. I mean, and I tell Patti this all the time, that if she wants me to come to something like this, give me 2 weeks' notice so I can tell my boss, and I'll be there. Not that I'll ask to come off, get off. She gives me 2 weeks' notice. I'll go tell my boss I'm leaving to come out here. He can either give me the time off or he can fire me. It doesn't matter to me. This is what I basically live for right now. To talk to the attorneys, meet with the attorneys, because I was talking to the young lady here, that if I can inspire one student that are at these to go that extra step, to meet with those kids, to meet with the parents, that's what I'm here for. If meeting me will do that, I'm here for you.
And we really, really appreciate you coming out.
It's my pleasure.